me, if I can just run very quickly through the permits and authorizations. I'm not going to go through all of them. I just want to say that the Department of State Lands issues 2 types of permits and authorizations: removal fill permits for removal or fill activity in waterways and wetlands, and proprietary authorizations. That's what that word is all about, proprietary. It's for use of state-owned uplands and waterways. Removal fill activity on state-owned waterways requires both permits and authorizations, and Jordan Cove is no exception. The state has removal fill jurisdiction, and the Land Board has directed that DSL is responsible for issuing or denying removal fill permits. The Land Board does not have any specific statutory authority over the removal fill program. So that lies all with me and my staff. And Jordan Cove Energy Project has several distinct removal fill activities and a wetland delineation report, and I'm certainly not going to go through all of those, but there are several before the agency. The state's proprietary jurisdiction, there is a discussion there about that we own the submerged and submersible lands, beds, and banks underlying all navigable and tidally influenced waterways pursuant to the equal footing doctrine. And Jordan Cove Energy Project has requested proprietary authorizations for a variety of project components, including easements, upland crossings, leasing, mitigation sites, sand and gravel, etc., etc. The Land Board has delegated authority to DSL to make decisions, including term and permanent easements. It has delegated authority to DSL to issue authorizations, and it has delegated Land Board authority for conservation easements and licenses. The only situation that the Land Board needs to intervene is the Land Board has required DSL to explicitly refer permanent conservation easements to the Land Board. And I will say that as of this time, there are none of those being requested in the Jordan Cove Energy Project application. Now, Oregon Administrative Rule also gives leeway for the director, discretion to the director, to refer unusual or controversial easement applications to the board, as well as a couple of other instances. But I will tell you, this director has no intention of doing that. This director believes that our agency, our department, our staff is quite capable of making the decisions. And you have given me the authority to make those decisions. So, in conclusion, the Jordan Cove Energy Project has applied for various permits and authorizations that are within the jurisdiction of this department, either under the state's removal fill jurisdiction or the state's proprietary jurisdiction. For each permit and authorization that is contemplated by Jordan Cove's most recent application, the existing statutes and rules place the obligation squarely on the department and the director for deciding whether to approve or deny the application. The Land Board's role is very limited, and considering the scope of this application, as I said, I'm not inclined to refer anything to the Land Board that I don't need to. So I just want folks to understand that while they may want to come here and testify to the Land Board, it really rests with the department. And we have nothing to discuss at this moment because they have asked us to suspend that application. When they refile, we will have a 60-day public comment period. I already told Jordan Cove Energy Project that I'm going to go outside the 30 days. And I said, this is an offer you can't refuse. And they agreed that we can do the 60-day comment period because statute requires only 30 days. We will go, we had already made plans to go to Coos Bay, Canyonville, and Klamath Falls. We had already arranged all of those locations, but we canceled those when Jordan Cove asked us to suspend the application. We will also require the applicant to put their application materials in all the public libraries in the affected counties. And there's quite a few of them. But that way, the public has an opportunity to review the materials. They're also available on our website. But like many people, I get tired of sitting at a computer and I like to print paper. They can go to the library and look at the paper, and they may not even have a computer. I will tell you, having previously worked in rural Oregon for the last 8 years for President Obama, I found a lot of communities that did not have computer access. So this is one thing that we will require of the applicant should they resubmit in August. So that's all I have on that front. Mr. DeVore, did I overstate anything or misstate anything?
No, I think that all sounded good.
Okay, then if you have no questions, I'll stand back.
I think we have a couple of questions. Treasurer Reed.
Okay.
Thank you, Madam Chair. Thank you for the memo and the discussion. I reviewed it before the meeting, and then through the conversation today, I was thinking about it as two other items unrelated came up. So I want to ask, not necessarily for an answer today, but for your consideration in the Department, perhaps the Department of Justice, if you can help us think through scenarios. What made me think about this was I was having the same conversation, or the same confusion you were about global and global. Thinking about the cost that we now absorb as a result of what's happened there, and thinking about the discussion about Superfund and what's happening there. So I'm thinking about the scenarios of what happens if there is a leak along the pipeline that creates pollution in a stream or a river. Thinking about a ship that docks and maybe results in a spill. Thinking about what happens after a tsunami and whether it's the landlord or someone else who would need to cover those costs. So, and what that looks like if it ends up being something like Superfund that ends up in not only the cleanup costs, but the litigation costs and the effort and so on. So again, not for answered today, but would appreciate the chance to get your reactions to that, perhaps with the Department of Justice assistance. Thank you.
Absolutely. We'll have a conversation about that. Thank you.
Thank you, Treasurer Reed. I have two comments for consideration. One is I appreciate the extension on the 30-day public comment period. Given the extensive time frame that the folks managing the project have had, I think it's appropriate that we provide ample opportunity for the public to weigh in. And so I would certainly ask for a longer period of time for public comment consideration. I don't know the regulatory framework around that or the statutory framework around that, so of course Department of Justice would have to weigh in on that, but I'd certainly ask for your consideration. The other thing is, my understanding is the pipeline impacts 4 counties, and given the challenges for folks to travel, I would certainly request that the department make the consideration of having a hearing or meeting in every single one of the counties.
Governor Brown, we actually looked at that. We couldn't find a location for the 4th county, but we'll take another run at that when we come back and plan ahead. And I will tell you, it's a significant burden and cost to the department to go out to do the public comment, because we have to have so many staff, we need to take public testimony, we need to have it transcribed. So we already contracted with a transcription service to do that. Having been a former court reporter, I know those costs can get high, but we are really crackerjack fiscal staff has worked out a contract that I think will serve us well. We need to have staff available to take all the testimony, the oral testimony, and we need to have staff present. I say it's a burden. The agency is happy to do it, but it does take an incredible amount of time, and we have to put ourselves up in hotels as we travel to do it. But we will certainly look at trying to find a location that will work for everyone.
The last, having had, I know that my Staff has had meetings with a number of the tribes recently. I believe there are at least 4 tribes directly impacted: Coquille, Coos, Cow Creek, and Klamath, and would certainly ask the department to ensure that there is ample opportunity for the tribes to participate and weigh in.
Governor, we are very aware of that. I have already met with the Coos Law and Quasais Law early on, and I'll be meeting with each of the other tribes, but we'll also make, this is another reason why we're doing Klamath Falls, so the Klamath tribe can attend. Coos Bay, there's 2 tribes there, and then Canyonville. We were actually citing the hearing at the casino.
Okay, great, thank you. Secretary Richardson, any comments? Okay. All right, so we have a list of about 24 folks signed up. We have, my proposal is that we provide each person with 1 minute. The other option is to give the first half or the first 15 or so 2 minutes. We've got another appointment following this meeting, so I'm open to board members if you have any thoughts.
I think that